Hi, my name is Darren Mills. I want to take a couple of minutes and help educate you on what are referred to as living documents. Obviously, as the name implies, those are the estate documents that make up your complete estate planning package that obviously relate to while you're alive. These documents would conversely, I eloquently tell people, think of it this way: they become toilet paper on your death. They no longer have any legal significance as far as you being able to continue to act on behalf of what is referred to as the principal or the person that is granting you the authority to do so, that is, to act on their behalf. So essentially, there are four of the living documents. There are your durable power of attorney, which deals with your financial matters, and the other three documents deal with your health related matters. So a healthcare power of attorney, a living will, and what I refer to as a portable HIPAA document, because HIPAA is federal law. So no matter where you are in the United States, who's ever listed on that document would have access to your medical records. Okay. So the first document I'm going to talk about is your durable power of attorney. This relates to, again, your financial matters. And what I tell people is that when you sign this, in Florida, they don't allow anymore what's called a springing power of attorney, which means it would only come into effect when you can't act on your own anymore. New Jersey still permits a springing power of attorney, but 99% of the time, the clients have them as immediate not springing, but immediate powers of attorney. Okay. So one of the important aspects of the financial durable power of attorney, because I do a lot of elder law planning, is to give the authority to your agent to actually make gifts on your behalf. Even though you're not allowed to gift for Medicaid as part of Medicaid planning, almost universally, my clients are making significant gifts of assets so that they can plan to be eligible for Medicaid at some point in the future. Without a effective power of attorney in place and somebody loses capacity, you only really have one choice, and that's a guardianship. A guardianship generally is uncontested, but if it becomes contested, it is actually, I tell people, it's full-blown litigation, right? So let's say one child petitions the court to become the guardian for mom, and another child comes forward and says, well, that child can't manage your own affairs, yet alone, mom, so I'm going to challenge that, right? It happens. And so in that case, you end up having effectively, full-blown litigation, as I tell people. So when you file for a guardianship, you have the attorney that is representing the person looking to be appointed as a guardian. The court will then appoint a guardian for the alleged incapacitated person. So off the bat, you have two attorneys. And then, of course, you're going to have medical professionals involved who are going to assess whether or not the alleged incapacitated person can, in fact, no longer act on their own. Okay. So again, guardianships can be expensive and time consuming. And, to the extent they can certainly be avoided, it's something that almost everybody should try and plan for. All right. So one other thing I tell my clients when they sign their power of attorney, they are essentially giving whoever the agent is the keys to the kingdom, and they can wipe you clean. Again, 99% of the time, it happens to be one child who the parent trusts immensely. And so, knock on wood, generally there's no issues, but unfortunately, a significant amount of particularly financial elder fraud happens by family members. Okay. And most of it is also probably not even reported. I've certainly had situations personally where one child was arguably committing criminal acts, and mom or dad did not want to press charges against their own child. All right. So the other piece of your living documents is your healthcare documents, and essentially there's three of those: your living will, your portable HIPAA document. Again, I call it a portable HIPAA document because whoever's listed on that document, and no matter where you are in the United States, they would be able to get access to your medical records. And of course, your healthcare power of attorney. The living will, I tell people, eloquently, is your pull the plug document, right? Everybody can kind of relate to that. And again, the overwhelming majority of my clients, certainly north of 95%, want a living will. I personally don't want a machine to keep me alive. That's no quality of life, right? So that's it. Those are your living documents. Importantly, anyone over the age of 18 should have these documents in place. People incorrectly, assume that it's only for our seniors. That's false. A lot of parents with the COVID pandemic were scrambling to get powers of attorney in place for their kids who are away at college, because if something happened, the doctors don't have to talk to them. Actually, they shouldn't talk to them without those documents in place. And so that can obviously be, create a lot more stress in those situations than is necessary. All right. If you have any questions, please feel free to reach out to me, and I look forward to helping you and your family. Thank you.